Hello and welcome back to another episode of the Injury Law Pod. I am your host, Eric Bartlett, 28-year personal injury lawyer, and this is the podcast where we primarily talk about all things personal injury law related. The calls are coming in. We're getting quite a few calls for people getting hurt, and what could it be? The weather. So I'm recording this here at the end of January, and we're having a real winter in Kansas City. And well, we as Kansas Cityans, we don't always handle this weather the best because we're not always used to real snowstorms and icing and all the things that came along here a few weeks ago that are continuing to create problems even now, several weeks down the road. And we're getting calls from people that were involved in car accidents because of the weather. And we're getting quite a few calls from people that have fallen on unsafe conditions on property. So I thought today would be a great time to visit a little deeper on what exactly a personal injury claim looks like when someone falls on an area that has snow, ice, something of that nature, and what options do they have for making a claim against the landowner, and when do they not necessarily have a very good opportunity for that claim, because Missouri law is specific in this area. And so it's not an automatic. A lot of times you hear people say things like, oh, if somebody gets hurt on my property, I'm automatically responsible. And that's not the case. In Missouri, you have to prove somebody was negligent, that there was a dangerous condition that they failed to remove or barricade or warn of it. If you're walking across somebody's property and you fall on your own accord, that's on you. But if you're walking across somebody's property and there's a dangerous condition that they either, again, could have removed it, warned of it, or barricaded it, or maybe they created it in the first place, well, that's a different story. Then, under the law, if you're hurt, you probably have a claim against that property owner. And, a few episodes back, I talked about black ice and about the dangers of black ice. And just to revisit that a second, black ice isn't black, it's clear. The reason it gets the name black ice is because if it's on like black asphalt, it's hard to see. It blends in. And if it's on concrete, same situation. It's just probably not black at that point, but it's hard to detect. And what happens is after a snowstorm, people go about the process of, clearing and removing snow, ice, and a couple things can happen. For one, they might remove the snow, but leave a layer behind that as the freeze thaw cycle goes into effect, temperatures warm up during the day, the sun's out, things begin to melt, and then overnight into the next morning, or a temperature drop, that stuff refreezes and becomes very dangerous, becomes a hazard to those who are walking and encounter it. And so as a landowner, property owner, whatever that looks like, if you have a business, if it's at your house, you have to take measures to protect people that are considered invitees to your property. What does that mean? That just means they are lawfully upon your property. They're not trespassing. So, good examples, right? At your house, you might have deliveries, Amazon, UPS, FedEx, US Postal, whatever it is. And if those people are making deliveries to your house, which at my house, we see the Amazon person way more than I would like, but they make frequent trips to our house, or FedEx or UPS. And, as a homeowner, I have to ensure that I've done what's needed to make the areas that someone is going to walk to my front door safe. And so not only are we responsible for clearing snow, things of that nature, but we also then have to do follow-up, make sure that it doesn't become an ice rink. And as a business, businesses not only have walkways outside of their businesses, they may have the parking lot area where their customers are going to park, and they're going to proceed to walk from their vehicle to the business. And they need to be on top of making sure that those areas are as safe as they can reasonably make it. Nobody is an insurer of someone else's safety. In other words, it's not like you have to do absolutely 100% everything right, but you have to take reasonable steps to provide a safe area for those who are coming to your home or your business. So again, just as a warning, right now there's tons of ice around everywhere. It doesn't take much getting out and about to discover that. So, number one, just be warned, be careful. It's very dangerous out and about. But then number two, we need to look at these situations where, whether it's a company or a private person, hasn't done what's reasonable under the circumstances to make their property safe. So let's deep dive a little bit on what exactly the law looks like when there is this weather. And again, precipitation, snow, ice, whatever that looks like. What does it look like in Missouri as far as the law is concerned? Well, and what you have to know as a general overview, the liability of a landowner for a fall on snow or ice, it depends on several factors, which includes the nature of the accumulation. So, is somebody claiming they fell on just the natural accumulation of snow or ice? So there's a snowstorm, let's say it's happening right then and there, and somebody's trying to make their way into a business and they fall. Is the landowner responsible? And then on the other side, artificial, right? So this is where the landowner has had time to work on clearing and treating the snow, ice, and again, has done something that's not reasonable in that regard. It's also another factor that we have to look at is the foreseeability of the harm. As the landowner, is what happened something that a reasonable person could have foreseen happening because of their actions? And then we have to look at whether the landowner took reasonable steps to address the condition. And Missouri courts have addressed this issue in various cases. And there's kind of about four things that generally determine the outcome of cases as they've developed through Missouri case law. So let's talk about natural accumulations. Missouri follows what's known as the Massachusetts rule. And that rule holds that a landowner has no duty to remove snow or ice that has accumulated naturally as a result of general weather conditions in the community. So, for example, there's a case out there where the court found that the icy sidewalk where the person that fell was a natural accumulation caused by freezing rain, and the landowner had no duty to remove it unless there was an agreement or a course of conduct that obligated them to do so. And in another case, the court affirmed that a landowner was not liable for injuries caused by a natural accumulation of ice during a winter storm. So right now, when people are calling in, I've already told everybody here at my law firm, we need to look at when the person is saying they fell. So we had this pretty significant storm around the weekend of January, I think it was 5th, 6th, somewhere in there. And if somebody's calling in and telling us that they fell during that storm, we're not going to be able to help them, most likely. I'm not saying that it's an absolute, but their case is much, much harder because of what the law is in Missouri. I mean, when it's an active snowstorm, basically, the lawmakers and the courts have said, look, we're not going to make somebody responsible when there's an active storm going on. And you can see why that's reasonable, right? Because when there's an active storm going on, somebody cannot keep up on top of snow removal, ice removal. I mean, just think about our roadways. That's why there's so many accidents, car accidents, when you're in the middle of a storm. Because even though the plow trucks are out, they're putting down, chemicals to try to combat these adverse weather conditions, the roads still get crazy bad. And again, this storm is a perfect example because it was a mess around the Kansas City area and everywhere that storm went through in Missouri. I mean, it moved from one side of Missouri, the western side, all the way across to the eastern side, leaving large amounts of problems, ice, snow, those types of things. And so, again, it's a very reasonable rule. They're just not going to hold somebody responsible during that kind of a situation. Okay, so let's talk about then the artificial conditions or affirmative acts by a landowner. And so if the landowner creates or exacerbates, right, makes it worse, a hazardous condition, then they may be held liable for that condition. There was a court case where the court noted that a landlord who undertook to address icy conditions, basically salting, they must do so with reasonable care. The court ultimately found that the landowner was not liable for the injuries that were caused by the natural accumulation of ice during a winter storm. And again, it's very fact dependent. What is the timing of this? And so again, what I've told everybody in our law firm and what we're looking at is how far away from the storm did the person fall? And the farther down the timeline that you get from that storm, the better case a person has against the landowner. Once you're several days down the road. If you haven't reasonably treated these problem areas, then the law is probably going to allow your claim against the landowner. And so it's very important. It's very factually dependent on the timing of all this. And so I know in our office, we've been keeping track of the timeline, because the problem is we're not only are we getting calls right now, just a few weeks after, but we're probably going to get calls months after, because people get hurt, they get seriously hurt, they're going through treatment, whatever that looks like. And at the time, they're not necessarily thinking about, do they have a claim against the landowner? But at some point, for whatever reason, and it may be due to the seriousness and the permanency of the injury, they start trying to figure out, what am I doing with these medical bills? What am I doing to try to make up for the time that I had to take off work? Those types of things. And that's when they start thinking about, do I have a claim? And so on our side of things, we want to be prepared. We can always go back. There are historical weather records that can be searched, but as a diligent personal injury law firm, I want to be on top of the timeline. It makes it easier for me to decide, is this a case that we think we can help somebody on or not? And we can move on pretty quickly. We can either work to help them or tell them we don't think we can be of benefit. So again, the artificial conditions or the affirmative acts, right? What was the landowner doing? Did they make the situation worse, or did they not do enough? Again, especially given the timeline, had there been enough time that there should not have been any serious hazards on their property? Now, another interesting part of Missouri law is the open and obvious danger doctrine. And basically, that doctrine holds that landowners are generally not liable for an open and obvious danger unless they should anticipate that invitees, which again, remember, people that are lawfully on the property, might still encounter the hazard despite its obviousness. Okay, so what does all that mean? Well, in one court case, the court held that even though the icy parking lot was an open and obvious danger, there was obviously ice everywhere, or at least enough that it was open and obvious to the public. The landowner, the court held the landowner could still be liable if they should have anticipated that invitees might be harmed despite exercising due care. So they're not just going to let a landowner off the hook by saying, look, there was ice everywhere. Anybody could have seen it. This person fell. They should have been more careful. Well, they're going to, the courts have basically said, no, it doesn't work that way, because you as the landowner know your land best. And if people that you got coming to your property, especially if you're a business, right, you're wanting to sell them something, provide them a service, you're inviting them to come to your store, you can't just say, hey, they should have been more careful. Because basically the courts have said, if the person that got hurt was exercising due care, they were trying to be careful, but this situation was out here that the landowner failed to take care of, the landowner can be responsible. So that's another factor that courts are going to look at. And then finally, the fourth one is that it revolves around the duty to warn or remedy the situation. And in some cases, courts have found that landowners have a duty to warn invitees or take reasonable steps to remedy hazardous conditions. And again, in another court case, for example, the court found that there was a genuine issue of material fact. That just means there was enough to push forward in the case that whether the icy conditions were open and obvious, and whether the landowner should have anticipated the harm, and therefore a jury should be allowed to decide if the person that got hurt was entitled to compensation for the injuries against that landowner. So, in summary, a landowner's responsibility for a fall on snow or ice, it depends on whether the accumulation was natural or artificial. And again, if there's a snowstorm, active snowstorm, landowner's probably not going to be responsible. Whether the danger was open and obvious. And again, this is not King's X for a landowner. They can't just say, man, there was ice everywhere out there, so they should have seen it. A landowner still has to take reasonable steps to treat it and do everything reasonably possible to make it safe for the people they've got coming to them. And whether the landowner took reasonable steps to address the hazard. And again, that's what I had just talked about. You know, you cannot just let it exist, do nothing, let it thaw, let it freeze, and become this really dangerous situation and just say, hey, this is what happened. I didn't do anything. It was open and obvious, so I'm not on the hook. It doesn't work that way. So best practices, number one, again, and we are in the perfect example because it's unreasonable to tell people, well, you just can't go out. I mean, we're 3 weeks, 2.5, 3 weeks out from a major snowstorm. So it's not reasonable to tell people, well, you just need to stay home. You can't go to the grocery store. You can't go to the gas station, right? I mean, that's not going to work because at some point, obviously people have to get out and about and take care of things they need to take care of. And so as landowners, you know, we are the ones that have to do what's reasonable to make our property safe. So the takeaway from this whole discussion is don't just let the situation get worse on your property. By the way, just as a side note, in most cities, there's an obligation on the homeowner to clear the sidewalk in front of their house. Not a lot of people know that, but there's usually a city ordinance that requires the homeowner within a reasonable amount of time to get their sidewalks cleared of snow, ice, those types of things. It's not the city's responsibility. It's the homeowners. And so just keep that in mind. But if you're somebody that has fallen on snow or ice, something of that nature, hopefully you can take what I've told you and you can use that to help guide you on whether or not you have a case. And of course, we're always happy to discuss it with you and give you our professional legal opinion on whether you have a claim or not. A lot of people get seriously hurt in falls during the winter, and we see a lot of them and we help a lot of people. And so if that might be you, feel free to reach out. And I would encourage you, watch this video that's linked up here for more information on black ice, because it's really important and it's a really big danger. And as always, I hope you found this episode useful, informational, and as always, please be safe, be well.